Good afternoon, dear participants. I'm very happy to welcome you in this session on the developments of new regulations in the fast-changing digital world. My name is Irena Nesterova. I'm a researcher at the Institute of Legal Science at the Faculty of Law, University of Latvia. New technologies are developing rapidly and playing an increasingly important role in all areas of our life, while they are also posing many new challenges that calls for reviewing the existing laws and also creating new regulation. In this session, we will explore various legal challenges that AI, other new digital technologies and online platforms pose and how they influence the development of the existing legal framework as well as possible future regulation. We will discuss EU proposals of Artificial Intelligence Act and the Digital Service Act, as well as the impact of AI and algorithms on existing data protection laws. We will also look to the impact of new technologies and judicial systems and legal professions. We will also find out how large digital platforms such as Facebook and Google influence the EU's digital policy and the legislators' decisions in countries. Before we start, I would like to inform you that this session is recorded. If you have any questions during the presentations, please write them in the chat and the speakers will answer them later in the discussion part after all presentations. And each speaker has about 20 minutes. Let's start our presentations. It's my great pleasure to introduce Helena Gundus, who is a professor at the University of Oslo. We are working together on the Norforsk project, Critical Understanding of Predictive Policing, exploring social implications of digital transformation in law enforcement. We will together present the first paper about EU proposal for artificial intelligence regulation and the need for stricter approach to biometric surveillance. I will start with the new rules proposed for surveillance technologies, and Helena will continue to talk about the risks of implementing such systems in national contexts. Now let me share with you the presentation. Okay. Can you see it? Okay, thank you. So, on 21st April, the European Commission published a long-awaited proposal for artificial intelligence regulation known as AI Act. It is the first initiative in the world that would provide AI legal framework addressing the risks of AI systems. The AI Act the AI Act puts fundamental rights at the core of Europe's AI approach. It aims to pursue two parallel objectives. On the one hand, it aims to foster the development, use, and uptake of AI in the EU. On the other hand, it creates the ecosystem of trust by seeking to ensure protection of safety, fundamental rights, and EU values. Although these objectives are distinct, they are also compatible. The AI Act should effectively enforce existing laws of fundamental rights by addressing the risks created by AI systems that requires also to introduce prohibitions of certain AI practices that violate fundamental rights and democratic values. The use of AI-based biometric surveillance technologies raises significant risks and threats to fundamental rights, in particular human dignity, the right to privacy and data protection, non-discrimination, the freedom of expression, and the freedom of peaceful assembly, as well as to the rule of law and democracy. The use of these technologies, in particular facial recognition, have raised broad debate on the need to introduce red lines. International organizations involved in the debate on the development of AI regulation more and more noticeably recognize the need to set red lines in the AI legal framework. The UNESCO draft recommendation on the ethics of artificial intelligence provides that AI systems should not be used for social scoring and mass surveillance purposes. The draft recommendation is submitted for its final adoption to the UNESCO General Conference that will be held in November. The United Nations High Commissioner for Human Rights, Michelle Bachelet, published a report in September that emphasizes the urgent need to ban AI applications that violate human rights, as well as to impose a moratorium on the use of remote biometric recognition technologies. Also, the European Parliament has urged the European Commission in a number of occasions to consider moratorium on the use of facial recognition systems in public spaces. In October, it published the resolutions that calls for a moratorium on the development of facial recognition systems, as well as for the prohibition of the use of automated analysis and recognition in publicly accessible spaces of other human features. The direction of the debate in Europe has been much influenced by civil society organizations. In particular, EDRI, that has launched the Reclaim Your Face campaign, and the European Citizens Initiative calling the European Commission to ban biometric mass surveillance practices, and the European Data Protection Board and the European Data Protection Supervisor, many research and civil society organizations have stressed the need for clear prohibitions in the feedback to the Commission on the proposed AI Act. So let's now look to the AI Act proposal and the new rules for the use of AI biometric surveillance systems and their classification. The AI Act proposes to categorize AI systems based on 4 different levels. They create an unacceptable risks, a high risk, limited risk, or minimal risk. AI biometric surveillance systems may fall in 3 categories. Remote biometric identification systems may be classified as prohibited AI practice, but may fall also into the category of high-risk systems. biometric categorization and emotional recognition systems may fall into the categories of limited risk or high-risk AI systems. The core question is whether this classification may meaningfully protect against the significant risks to human rights these systems raise. So, AI Act prohibits certain AI practices that create unacceptable risk as they contradict EU's values and fundamental rights. One of 4 prohibited practices is the use of real-time remote biometric identification systems in publicly accessible spaces for law enforcement. However, this prohibition is very limited and would allow a wide range of surveillance practices. The prohibition applies only to real-time biometric identification systems, thus allowing non-real-time or post-identification, which would be classified as high-risk systems. It doesn't cover online spaces and would not won't prohibit law enforcement authorities to use facial recognition software services like Clearview AI. The prohibition allows remote biometric identification in publicly accessible spaces by public authorities, also for other purposes than law enforcement, as well as by private companies, both in public and private spaces. In addition, the AI Act provides an exhaustive list of exceptional cases in which the prohibition does not apply. Hence, the use of these systems by law enforcement purposes would almost always be justified and would not be able to prevent the use of AI systems for mass surveillance. The introduction of the prohibitions in the AI Act by itself is a significant step forward to the heavy debate at EU and international level on the need to set red lines to AI practices violating human rights. At the same time, the scope of these prohibitions is strictly limited and contains multiple exceptions which should be removed. AI systems may be classified also as high-risk systems. The AI Act sets out a wide range of legal requirements for these systems, such as the obligation for risk assessment and management, testing, the use of high quality of data sets, documentation and record keeping, and others. In addition, providers of high-risk AI systems shall ensure that their systems undergo an ex-ante conformity assessment procedure through internal checks prior to their placing on the market or putting them into service, with the exception of remote biometric identification systems that would be subject to third-party conformity assessment. However, such internal assessments could quickly devolve into meaningless box checks. Therefore, third-party conformity assessment should be required for all high-risk systems. There are other shortcomings of the AI Act. For example, there is no reference to the rights of individuals, as well as complaints and redress mechanisms available for individuals and communities affected by AI systems. Biometric surveillance systems are regulated also by data protection law, and it is acknowledged in the AI Act that the classification of AI systems as high risk does not necessarily make them lawful. However, the AI Act lacks a clear obligation to comply with data protection law, which should be introduced. So Annex 3 of the AI Act identifies many different areas in which the use of AI systems creates high risk. Remote biometric identification systems, except those which would be prohibited, are classified as high-risk systems under the area of biometric identification and categorization of a natural person. Another high-risk area is law enforcement. In this area, AI-based predictive policing tools and AI systems used as polygraphs or to detect the emotional state of a natural person are also classified as high risk. Emotion recognition and biometric categorization systems may fall within a category of high-risk AI systems depending on the area it is used. For example, if they are used in the areas of education, employment, law enforcement, and migration. However, these systems are generally classified as systems raising limited risk, which are subject only to limited transparency rules. These systems deeply affect the enjoyment of the right to privacy, carry inherent risks to discrimination, and may undermine other human rights, such as the right to liberty and to a fair trial. However, there is no scientific evidence of the effectiveness of their use. So the European Data Protection Board and the European Data Protection Supervisor has recommended to ban emotion recognition and biometric categorization systems and predictive systems in law enforcement. They also call for a ban on any use of AI for an automated recognition of human features in publicly accessible spaces in any context. This opinion has been endorsed by many other organizations. The classification of biometric surveillance systems which contradicts fundamental rights and are scientifically unfounded as high risk or limited risk AI systems could normalize or even legitimize their use. So it can be concluded that the proposed new rules and the classification of these systems in the AI Act should be reconsidered in order to meaningfully address the risks they pose on fundamental rights. So, and now I would like to give the floor to my dear colleague Helena, who will share with you practical examples which we are exploring in our CAP project. And
thank you so much, Irina. It was very useful and exemplary framework for discussing the different types of risks that we are going to explore together in this project. And as you told, we are Northforce project, where we are 7 partners, organizations from Denmark, Norway, Latvia, Estonia, and the United Kingdom. And we're also going to have a case study in Sweden, where we are exploring the digital transformation of law enforcement and its impact on crime detection and prevention. And one of the binding concepts that we are going to look into is definitely predictive policing, which are in a way methods to forecast what crime is going to be occupied in the future. So it's a forecasting model. It's the use of intelligence. And the starting point is that predicting crime is not an objective and a true practice. And we also know very much little about the risks that emerge with the use of digital data in practice. So this is a combination of different interdisciplinary scholars from social science, and we also have arena as one of those who are going to look at the regulations and also upholding of the transparency and also human rights in the different cases that they have selected. So we are in a way in the start and the beginning of having the empirical cases done. Some of it is looking into documents. For example, in Denmark, they are looking into the introduction of Polintel. It's Palantir technology used and by the Danish police that are looking, they are going to interview and also look at why they bought it and why they implemented it, and also in which direction it is going to predict different types of crime. We don't know so much of how it is going to be used at this moment. So this general crime, that is the case. In Norway, I'm going to talk a little bit about it later. We are more looking into youth crime. And we also have started with, in a way, comparing with the introduction of the more artificial intelligence technology that are introduced in the Danish case. So that is one of the starting points for the Norwegian case, where we are going to look at significant or contextual aspects of education, for instance, discretion, and also what type of data that are put into the predictions, for example, automatization of data, Internet of Things, real-time analytics, for instance, and explore how these aspects influence the decision-making processes and discretionary power with the police systems and by the individuals. So this will, in a way, help us identify the risks with the data from, as Rainer talked about, the minimal to limited risk to also the high risks. And as you also talked about, it is in a way, law enforcement's data is very much high risks data. And if in a way it is very much automated, it's going to be also, and also using sensors as biometric identification, also social media and different types of not police registered and verified information to predict what is going to happen in the future. There's also definitely a high risk. You see that in the UK case, they are using facial recognition as the case in the St. Panacry place, and how they're using it to urban public space policing in London. And in Sweden, they are also looking at how the private guards are using different types of data. And this is not, in a way, started yet, so it will be interesting to follow up to identify which grades of risks that are implemented in the data that are collected and also analyzed in these studies. In the Latvian case, there will also be a project looking into the road traffic safety system and different cases concerning future intelligent transport system, unmarked police bus with the 360-degree camera, drones and smartphone apps. And in the Estonian case, they are more looking into biometric data and also migration and also the input of different types of e-residency and digital migration identification documents and also border control. So we are in a way trying to combine and say more comparatively what this will look at and to what degree there are risks with minimal and also those data that are limited risks with, how they are, when they are applied, what we can see of more, in a way, unacceptable risks with them. And we are going, if you take the last slide I have, Arina, we are going to use a framework for analyzing to what degree we can see move towards more big data surveillance in these types of cases, because a lot of those data that are used and collected and analyzed are not in a way big data. There are data collected from the police in more intelligence processes, but we are not so much aware of, as I told you, what types of broad data that are collected. So we can use these analytical questions to the different cases inspired by a study by Sarah Brain. She's looking into predictive policing in LA and how it's used in law enforcement there. We have 5 analytic questions regarding the degree of big data surveillance that will be reflected by upon the projects to identify the degree of in a way surveillance. And the questions are: to what degree are discretionary assessments of risk supplemented and quantified by using risk scores? The second question is: to what degree are data used for predictive rather than reactive or explanatory purposes in practice? We know that a lot of these systems, they are in a way also more collecting real-time data. It's not so much used to predict in the long term, it's more strategically. It's very much a response in time. That's what she finds, Sarah Brain, in her study. And to what degree makes the proliferation of automatic alert systems it possible to systematically surveil an unprecedentedly large number of people? It's not only model-based in a way. You have a theory that are questioning about, we want to have more information about that city, part of the city, or that person in a way, but there are coming up alerts with red flags, for instance. And to what degree do we see it is a threshold of inclusion in other databases than the law enforcement databases, including, for example, people that did not have any police contact beforehand? To what degree are there much broader characteristics of profiles that are integrated? And the last question is: to what degree are previously separate systems merged, facilitated into the spread of surveillance and into a wide range of institutions, for instance, health, tax, social service and welfare institutions, and also how it is integrated with, for example, big data from social media. So thank you so much. That's what we are going to study on the upcoming 2-3 years now.
Great, Helen. Thank you so much for sharing, giving insight into our project. It was really nice. I'm now going to stop sharing. Okay, maybe someone, does anyone have any very urgent question about the project or about presentation? If no, we could proceed with our next presentation, and of course you will have an opportunity to ask your questions also later in the discussion part. Now we will hear about other EU regulation proposal which introduce new rules for platforms and online marketplaces. I would like to give a floor to our next speaker, Vija Kalniņa. She is a PhD student at the Faculty of Law at the University of Latvia and also a judge at the newly formed Court of Economic Affairs in Latvia. She will present a paper on liability of intermediary service providers in the Digital Services Act. Vija, the floor is yours.
Thank you, Irena. One moment, I will try to share my presentation. So, do you see the presentation properly? Full screen. Okay. So yes, thank you very much for the opportunity to be here and talk about the IT law challenges. Thank you, Irene, for this opportunity. I'm very honored. So yes, as Iran mentioned, I am a PhD student here at the University of Latvia, and currently I'm writing my thesis on one of the 4 economic freedoms, the freedom to provide services in the sharing economy. And the E-Commerce Directive that I'm going to mention today a lot is very important in ensuring the freedom to provide services, and not only for the sharing economy services, but for most of the digital services. And since the end of the last year, one cannot speak about the E-Commerce Directive without mentioning the Digital Services Act, which is going to modernize and replace a very significant part of the E-Commerce Directive, the rules regarding the liability of intermediary service providers. And this is the topic of my today's presentation. And here is the plan, what I'm going to talk about today. I will briefly describe the current state of play. Then I will explain what problems have emerged and why there is a need for a new regulation. And after introducing the Digital Services Act, I will do a little comparison of the E-Commerce Directive and the DSA. And then I will, one of the main differences is new obligations and responsibilities for intermediary service providers, which I will talk more in detail. And lastly, I will present my conclusions about this Digital Services Act and its impact on the liability of intermediary service providers. So, the E-Commerce Directive, as you can see from the number of it, was adopted quite a long time ago, 20 years ago. And the main goal of it was to ensure that the EU can provide open and secure place for new digital services to develop. Therefore, we can see in this directive, its main what the directive is putting emphasis on is establishing various beneficial rules for digital service providers. And most significant are those rules that are included in the section 4 of this directive called liability of intermediary service providers. And it includes only 4 articles. These 4 articles concern intermediary service providers, that are 3 types of them: transmission of information, catching, that is a little bit more complicated transmission of information, and also hosting. And hosting is not only saving your information using hosting services where one stores information on servers, but also any digital service that offers its users to store, publish, or spread information. So any kinds of platforms, social media, trading platforms can qualify as hosting service providers, and thus they are intermediary service providers. And so Articles 12 to 14 of the directive establish that the intermediary service providers cannot be held liable for information or content that is being transmitted and or stored by their service users if the service provider is impartial and neutral. That means if the service provider does not initiate the transmission, does not modify the information, does not have actual knowledge of illegal activity or information, this service provider cannot be held liable for the information that has been transmitted or published using their services by third parties who are using their services. And then the article number 15 is also very important. That establishes no general obligation to monitor principle. That means that EU member states cannot impose an obligation on the intermediary service providers to monitor information, actively seek facts or circumstances indicating illegal activity. These are, of course, very significant benefits for service providers. they give them more freedom to develop their services, use their resources for the development of services and not for fighting or seeking illegal content on the internet. However, 20 years have passed and the situation has significantly changed. And despite that, not once the E-Commerce Directive was amended. And here in the slides, I have included a list of main problems that we face today, but this directive cannot address or solve anymore. First of all, the directive cannot provide sufficient protection of fundamental rights. There is no solution or regulation at all for automated messaging. It was not topical at the time when the directive was adopted, but nowadays it's very, very popular thing that is happening and what we are facing. Also, many new digital services have emerged during those 20 years, and there are some of them that for some reason are outside the scope of the directive, and the directive is not applicable to them. And also, we can see from the directive that it very much focuses on limitations of liability of the service providers, but does not offer solutions on how to deal with the necessity to delete or take out illegal content. So digital single market has been a priority already for the previous commission. And we can see that they have taken many serious steps to create and to strengthen the digital single market. And the digital single market has remained one of the top priorities for the new commission as well. And following their statements, last year in December, the European Commission presented the proposal for the digital the Digital Services Act. And here in the slide, I have highlighted the main goals of the Digital Services Act. First of all, they want to ensure more legal certainty. This act will be adopted in the form of a regulation that definitely, without any doubt, can secure a better harmonization than a directive. Next thing is that they put an emphasis on the necessity to create safe online environment, and it must be created involving the intermediary services providers as well in securing this goal. And then this act determines that measures need to be taken to secure a safe environment. And of course, they need to be balanced. The balance and proportionality must be ensured. And it must be ensured with fundamental rights, especially freedom of speech, so that any measures taken against the illegal content does not breach the freedom of speech or other fundamental rights. And then one last very important thing that is introduced with this act is multi-level supervision of intermediary service providers with stronger cooperation between national institutions of member states. And yes, then how are they going to achieve those goals? First of all, Digital Services Act will replace and modernize not the whole E-Commerce Directive, but only 4 articles that I was talking about before. Articles that limit the liability of the intermediary service providers. Secondly, the Digital Services Act establishes an institutional system for supervising the intermediary service providers. And to understand it correctly, the goal is not to control these service providers, but rather to support them to help clearly identify illegal content and precisely address it. So let's look more closely at what will happen with the 4 articles from the E-Commerce Directive. So articles that concern the transmission of information will basically remain unchanged. But that is quite understandable because the problems mentioned today are not really created by these services. Then if we look at the Article 14 that limits liability for hosting service providers, we can see that the idea is still there. It remains unchanged. Also the wording and formulation of this article will remain quite similar, but we can see that there are added exceptions from the liability limitations regarding distance trading with consumers that will concern large platforms. And as an example that could be given is Amazon. As we know, Amazon is a trader itself. They trade their own goods, but also using the platform, other traders can trade their goods to consumers. And probably sometimes there might be confusion for consumer from which person they are buying the goods. And if they have reasonable reasons to believe that they are buying goods from Amazon, then in case if they have concluded the contract with a third party, other trader, Amazon might be held liable for the actions of this other trader. And then the last article number 15 that determines the principle of no general monitoring obligation is also, we could say, the first part of it, and the principle is taken in the Digital Services Act, but in the following articles 8 and 9, the Act will have more specific and clear procedure how the national institutions need to act and inform service providers about the illegal content, what information they need to provide to request any activity from the service providers, and also a specific procedure how to request information from these platforms. But of course, if you open this DSA, you will see that it consists of much more than only 4 articles that will be taken from the E-Commerce Directive. As I mentioned previously, DSA aims to involve service providers in achieving its goals. This is the main change in comparison to E-Commerce Directive. We here in slides, you can see quite long list of obligations that will be imposed on intermediary service providers. Seeing this long list of obligations, of course, raises the question, does this comply with the principle of no general obligation to monitor the content? Because at first, if you read this list, at least I had questions. Isn't this at least some of these obligations on the edge with this principle? However, after carefully analyzing these obligations, I came to the conclusion that the Commission has very carefully, and I could also say successfully, avoided imposing any general monitoring obligations. Firstly, general monitoring of information online is not the only instrument or way to achieve the goals of the DSA. Secondly, the monitoring does not have to be done only by the service providers. It can also be performed by third parties that are the users of the digital service or trusted flaggers. And after that, when they identify illegal information, then the service providers can just react to specific identified cases and illegal content. And that is definitely much more easier and less resources demanding than monitoring and checking all the content saved and hosted by these service providers. So yes, and so now to the conclusions of the research that I have done. first of all, if we are talking about liability or transmitted or stored information, the DSA does not introduce significant changes. Norms are basically taken from the E-Commerce Directive and with the same wording copied in the DSA. Secondly, we can see that DSA illustrates a strong commitment to the principle of no general monitoring obligation. Also, when I was checking the documents, preparation documents for this act, I found that in every document they try to emphasize that this principle is very central and very important if we are talking about securing good environment digitally. And we can see from the rules included in the DSA that this is really respected. Thirdly, the DSA offers alternatives to the general obligation to monitor. I would say that they have been very creative in finding these alternatives. And that is the list I showed you before. That is quite a long list of new obligations that will be imposed on service providers. Then after checking what these new obligations require from the service providers, it can be concluded that none of them is a general obligation to monitor. There is one exception, obligation for very large online platforms that is defined in the Article 27 of the DSA. It could be argued that these obligations, namely to put in place reasonable, proportionate, and effective mitigation measures, could be on edge with the principle, but it's open for discussion. And then what is also significant, the proportionality of the obligations is achieved and their burden on service providers is limited based on the size or type of the service provider, and that was also illustrated in the table that I showed you previously. And lastly, we can for sure argue that adoption of the DSA in the form of regulation will definitely achieve a higher level of harmonization and uniform understanding of what activities can be expected from the service providers and how the liability limitations work. That would be all from my side. Thank you.
Thank you so much, Vija, for your very interesting and insightful presentation. Now it's my great pleasure to give the floor to Nicholas Kyriakides and Jaunā Šrikande. I'm sorry if I spelled it incorrectly. In their presentation, they will look at how AI and digitalization has revolutionized the legal profession in Europe. So the floor is yours.
Thanks so much, Irina, and hi everyone. I'm going to share my screen quickly. Myself and my colleague Jaunā are going to share with you some insights of our current research with title Race to Revolutionize the Legal Profession in Europe. Just a second, please. You can still see my presentation?
We can see the first slide now.
Excellent. Okay, so to start with, it is commonly known that technology has pervaded every aspect of modern society, especially after the pandemic. And it may come as a surprise to some that a large proportion of the legal profession is still hesitant to absorb some new technologies such as artificial intelligence. For a long time, the legal sector has relied on technology for storage, communication, and management. And now AI is being used to handle document disclosure and other responsibilities. Recent news reports anticipate that AI judges will become a reality and that AI will play a more prominent role in judicial chambers. For example, Estonia has announced plans to outsource some lower value cases to an AI-powered online court. However, other nations like the United Kingdom have only looked into methods to incorporate AI into the legal system so far. Our research aims to compare the rate of the reforms made by the United Kingdom, arguably a pioneer in the area of justice reform, with the reforms made in Estonia. With a global trend towards digitization, we hypothesize that the UK would benefit from following Estonia's approach to improving access to justice. And our research and analysis particularly considers the application and interaction of these two legal systems with AI. AI is defined as the broader science of designing computers to act intelligently without necessarily being explicitly programmed to reach particular outcomes. And I should say at this point that Estonia was used as one of our two examples because it is widely recognized for having an advanced e-government system. And despite its small size, Estonia developed the world's most sophisticated digital society in the last 25 years. And there is widespread agreement that this has benefited its citizens a lot. Many believe that Estonia's success is due to obligatory EIDs, digital signatures, and the national integration platform X-Road. The latter opened the doors for many public e-services, private sector services, and semi-public services, such as an e-health system, which is a centralized paperless system for issuing and handling medical prescriptions. On the other hand, English law has evolved in stages by relying on flexible basic concept to respond to new technology. This trend has continued in the case of artificial intelligence, and there are significant uncertainties about the application of English legislation to regulate AI. And our question is, will the courts deal with concerns about digitalization and AI on a case-by-case basis, or will new legislation and regulations be required? The solution is still not apparent, but it will almost certainly entail both. Despite the early improvements, it is crucial to note that the roadmap for the advancement of background legislation in the United Kingdom remains unknown. And now let's dive into some further details about Estonia and by my colleague Jaunā. Then we'll move forward with the United Kingdom and conclude with our conclusions.
Thank you, Nicholas. I just wanted to say that the slide's still on the first one. So
yeah.
if possible, if you could
I also wanted Thank you.
Yeah. Thank you. Yeah, so as Nicholas mentioned, Estonia has been known to be a pioneer in the use of AI and tech in the legal system. And this, in a lot of countries, they've characterized Estonia as a place where citizens have immediate judicial accessibility and protection. Some of the reasons why this is the case is because Estonia subsidizes the costs for e-services for its citizens. And what this has led to is that recently in the 2020 Justice Scoreboard, which looks at efficiency and speed, Estonia ranked in the top 3 EU countries, which was very commendable and formidable. Achieving something like being in the top 3 in this ranking is very notable. And the reason why is because of some of the infrastructure and frameworks that Estonia has put into place. And our paper basically navigates some of those notable achievements and highlights what was so impressive about them and why they should be scaled for other countries. One of the first things that Nicholas has already mentioned is the X-Road. That basically provides a direct communication medium between various government information systems. And this basically makes sure that all the systems have homogeneous access to information and there aren't discrepancies in the same material that's being received by each government organization. There is also a Center of Registers and Information Systems, which is the RIK, and that's a state agency that creates an integrated environment of e-services and develops new IT solutions. So not only has Estonia relied on the X-Road to make sure everyone has the same information, they also have an agency that ensures that this software continues functioning well for all of the relevant government systems. There's the e-filing system, which is a digital information database where all the electronic documents and materials are stored. And what this allows is for the simultaneous exchange of information between different parties. So this isn't just exclusive to the government systems, it extends beyond to citizens as well and ensures that basically all parties in a court proceeding would be on the same page. Estonia has also created the court information system specifically, which is a legal reform, that's the KIS. And that is a uniform information repository for every kind of court case. So all information management with regards to parties as well as the court occurs on this system. The parties can use it to register court cases, hearings, view judgments as well online. And this is quite impressive and not something that a lot of other countries have integrated into their legal system. This brings us to the broader conception of how Estonia has digitized their courts. For example, in Estonia, parties receive their final decision digitally. So they don't have to rush to attend court, especially in civil litigation proceedings and small claims proceedings where parties can be quite busy and may find it difficult to geographically visit this particular court at that specific time. The other impressive reform is the fact that they've simplified bringing a case to court into just a 3-step process. This is the 3-step civil case online process. The first is that the claimant accesses the e-file system with their ID cards and can then initiate proceedings. This makes sure that there is no discrepancy in who the party is to this particular case. The second step is then that they have to provide digital signatures that are verified with their ID cards and have to use internet banking to pay the nominal court fees to start the processing of the case. Then the third step is that the claim is saved in an e-file and can be accessed by all relevant judicial staff to review this e-file through the KIS and process it and decide whether they would like to go forward with a hearing. And then if they do go forward with a hearing, this can be done digitally. Nobody needs to necessarily come into court and present their findings in person. And this basically made sure that Estonia was very well prepared for what happened during the pandemic specifically, because it was a lot more difficult for individuals to be in the same room, in the same environment due to the virus. Specifically during the pandemic, almost 60% of court hearings were held digitally, and the few that weren't was simply because it wasn't scalable for those specific cases and fact patterns. What Estonia shows us is that to improve efficiency of courts, we do not need to increase manual labor or the number of individuals involved in the litigation system. Over the last 20 years, the judge numbers in Estonian cases, in Estonian courts have been the same, but the number of cases themselves have increased dramatically. even in this regard, Estonia still continues to operate on one of the most economical capita budgets in the EU. So not only is integration cost efficient, it's also labor efficient. And then the final development we wanted to highlight was their electronic ID card system, which I personally think is quite an impressive reform and should be brought in a lot of other countries. This system is considered to be the most developed ID card system worldwide, and almost 98% of Estonians own one of these electronic ID cards as of July 2021. 67% use it on a regular basis. This particular statistic is brought to light in our paper just to demonstrate that there's high participation rate from citizens in Estonia when it comes to AI and tech integration. And they've also agreed to sort of link their digital signatures to their ID cards so that all the e-services they access and all the government databases they access link back to their specific identity. Estonia has also, as Nicholas mentioned, been looking into integrating AI into their legal system, specifically into their small claims courts. So this is called the Robot Judges Pilot Program, and it's meant for small claims that are within €700 budgets. The way it works is that the relevant evidence and data is inputted onto their standard e-filing system, and AI software is used to process this data inputted, as well as to process the judgment patterns and previous judgments on such cases to come to a decision that will be quite similar to what an actual judge would do in that case. And this is quite impressive for the simple reason that the AI is thinking essentially beyond simply the facts that are being provided to it, to also judgment patterns that actual judges partake in. We find that the reason why such a development is feasible in Estonia is because of the pre-existing tech infrastructure, specifically the fact that everything is done online. So giving access to data to the AI isn't as difficult. It's also possible because of the national attitude towards AI in Estonia, which is overwhelmingly positive, as we saw when electronic ID cards were introduced for the first time in 2006. I will now hand over to Nicholas to discuss how this can be scaled in the UK.
Thank you, Arunima. I'll go on and talk about the current state of affairs in the United Kingdom. So well, the United Kingdom is a classic example of a country which attempted to inject to its court an online civil justice system. Sir Geoffrey Voss, the Master of the Rolls, shared in his speech that the online justice system would aim to reduce expenses and delays of the present paper-based approach, as well as allowing the collection of extensive data. And the program for digitalization of the judicial system was named the Reform Program, and it would aim to use digitalization as a way of aiding the vulnerable in getting justice as fast as possible, where it would at the same time support litigants in person without legal representation. Starting from 2016, the United Kingdom government attempted through Her Majesty's courts and tribunal systems to introduce the reform program, which had a budget of over £1 billion, involving over 50 projects. And the reform was split into 3 different phases, where all phases would eventually be realized across the next few years. At the time, the first phase of the reforms was introduced. The early versions of online divorce, excuse me, probate, civil money claims, social security appeals, and online plea services was tested. During the second phase of the reforms, the system opened up more to the public. The online services were more widely used, and however, they also introduced multiple pilot schemes in specific areas concerning public family law and immigration and asylum tribunals. And then the third and final phase involves scaling up of services and processes to ensure wide availability to all types of people. I should also mention that plans were also drafted to build upon the proposed online justice system after the above mentioned systems have been commenced. Concerning the process of continuous alternative dispute resolution, Sir Terence Atherton has expressed in his speech that the suggested integrated ADR mechanism will not be fully automated, since case officers will be there to assist the parties in managing their claim and aiding into facilitating a settlement. And now I will briefly refer to some of the criticism that the reform program received. I mean, the progress that the reform program has achieved should not be left unnoticed, but it goes without saying that it also faced its fair share of criticism. First of all, the House of Commons Justice Committee shared in its second report that in 2019 that serious concerns existed about the effect on access to justice, and its efficient dispatch of the current tribunal modernization program. Another main criticism that arose, one other of the main criticisms that arose was the ever-increasing budget. During the initial launch in March 2014, Her Majesty's Court Tribunal Service was given a one-off investment averaging up to £75 million per year. In order to financially cover for this investment, the courts are bound to make long-term spending reduction, starting by running a smaller estate. So a lot of courts had to close down. These court closures are particularly pertinent in light of their impact on the most vulnerable in the society. The Justice Committee noted that poor digital skills, limited access to technology, and low levels of literacy and legal knowledge were the main reason why barriers were raised in accessing new services provided by digital means. The reform program has also been criticized on the basis of the piecemeal approach that it adopted. And as it was pointed out, this piecemeal reform has implied that some courts, due to their higher attention given to them, were more advanced than others. And now finally, some suggestions on how these risks and concerns of the reform program can be mitigated. First of all, the Master of the Rolls expressed in a speech that the integrity of the adversarial process is not as vital in hindsight, since an online dispute resolution system would be a better and a more sensible in an economic perspective way of dealing with disputes. rather than everything being directed to a hearing at which the dispute is acted out in a single gladiatorial process. Alas, what is inferred by this statement is that the master of the roles discredits or at least diminishes the importance of the adversarial process. However, according to Professor Zuckerman, the use of machines for representation and adjudication would change the adversarial system to such a high degree that it will come to a point of no recognition. Furthermore, in their book, The Future of the Professions, Susskind predicts that over decades, there will be technological unemployment in the professions, suggesting that there will be no sufficient growth in the types of professional tasks in which people have the advantage to keep most professionals in full employment. While the Susskins consider a range of developments in technology, such as exponential growth, increasingly pervasive devices, and increasingly connected humans, as well as AI, they assert that developments of AI systems in the 2020s are likely to have significant impacts on the professions. Thus, one of the consequences that will arise with the introduction of AI will be that solicitors will no longer be gaining skills in judgment by working their way up through the ranks, since an AI machine will be mainly performing all the important tasks. And I will now hand over to Aronima to conclude and briefly mention some of our conclusions and suggestions.
Thank you, Nicholas. If we could just move to the next slide. Right, so as Nicholas mentioned towards the end of his part while discussing the UK as well, is that AI integration is essentially inevitable and often a common goal for most developed countries. It is very unlikely that most developed countries aren't headed on the pathway of integration of AI and digitization. Estonia specifically has become a role model for AI-based legal systems. Countries like Finland, Iceland, Ukraine, and Namibia, for example, have been looking to Estonia's model to decide how they will integrate AI into their systems. And Professor Zuckerman, whose paper we look at a lot in our paper, talks about how no economic activity has escaped AI transformation, and the UK is no exception. So that is sort of the trajectory in which we're headed. But the difference that lies between all of these systems in terms of AI integration is the scalability, which is the degree and time taken for AI integration to occur in each nation. And what we realized in the paper, especially while discussing what's happening in the UK, is that the scalability of AI is highly contingent on multiple internal factors. For the UK specifically, these are population size, internal culture and attitude, reliance on discretion, and pre-existing infrastructure. Population size, for example, Estonia has 1.3 million people as compared to the 67 million people in the UK. And this makes it harder to get the entire population involved in taking on any new AI reforms. In Estonia, this was a lot more feasible because there was a much smaller group of people they had to bring in to make a reform that was accepted by most of them. Internal culture is particularly interesting. The UK has a very high morality focus. Professor Zuckerman specifically talks about how an algorithm may rely on factors which are statistically significant, but morally wrong to consider in decision-making. And what this is hinting at is that the morality element in judgment that is so crucial to decisions in the UK cannot really be carried forward into AI judgments. And so they may not be scalable for the UK. There's also the reliance on discretion. In the UK, there's a right of discretion for all authoritative figures and officials. And the only way AI can step in to make decisions about relevancy and context is if it was conferred with the ability to have such discretion, which is highly unlikely at this stage. And so the only way AI can actually make decisions in a UK legal system is if the discretion of authority in those particular cases was reduced to zero, and the outcome of that case was relatively clear because the facts for that case were quite indisputable. And so because of judgments on relevancy and context, AI may not be scalable for the UK in the capacity that it was in Estonia. And then the last point, which is pre-existing infrastructure, the reform program in the UK is obviously bringing us closer to a point where there is infrastructure to bring in AI. But at this stage, the UK hasn't reached that place yet. And so it has to be the piecemeal process the UK is following to gradually reach a point where they have enough infrastructure to move to an AI and technologized legal system. Thank you.
Thank you so much for your interesting presentation and for comparing practice from Estonia and the UK. The next speakers will also come from Estonia, University of Tartu. However, we have deserved a break. I know we are a bit late with our presentations, but still like 3 minutes, I think we can have. So let's meet after 3 minutes. Maybe let's wait one more minute, maybe when everyone will come back, and then we will continue with our next presentation. Okay, I see. I think we could start, and now I would like to give the floor to Liva Rudzīte and Alexei Kelly from the University of Tartu, who will present their paper on the interaction between algorithmic transparency and legality. Please, Liva, the floor is yours.
Thank you, Irena. I will share my screen. Hope you can see that. Yes, you can see that, yes?
I will ask the first slide. Maybe you can check whether it goes.
Yes.
Okay. Yeah. No,
yes. Yes. Thank you, Irena, for the great pleasure and honor to present today the thoughts on such an important topic as impact of digitalization to regulatory framework. My name is Liva Rudzīte, and I'm a PhD student at Tartu University. And today I'm going to present you a research that is co-authored with Professor Alexei Kelly on the topic of interaction between algorithmic transparency and legality. And the aim of the topic is to outline what challenges algorithmic transparency may face in the legal framework of certain aspects of data protection in the European Union, as well as regarding the fulfillment of criteria sufficient disclosure in the patent legal framework under the European Patent Convention, as well as to analyze the proposed solutions and their sufficiency. So artificial intelligence and its subfield machine learning basically focuses on how to find the right features to build the right models to achieve the right tasks. And artificial intelligence and machine learning in its sense entails various steps and various models, starting from the most traditional ones to more sophisticated ones that deploy neural network and deep learning. And the more sophisticated the model is, the more accurate the result. And also these more sophisticated forms of artificial intelligence, machine learning, are more favorable in fields where the generalization of the result is important, or where, because of the data itself, traditional models cannot be as appropriate. For instance, genetic data is heterogeneous in nature, so therefore traditional models cannot process them. But with the sophistication comes also the problem of transparency or interpretation. Stepping back a bit, traditional programming from the machine learning differs by its nature. For instance, traditional programming itself is data plus program is the output, but in machine learning, data plus output is the program. So computer is the one that reads the intercorrelations between data without specifically programmed logic from the programmer. And so, yes, as I mentioned before, with the sophistication of the model comes also the so-called black box paradigm, or that may appear in two cases. First one is inability to explain the underlying logic of the model, and second is because of deficiencies or misrepresentation in the input or training data, or in other words, because of the biased nature of data. And since the data plays a crucial part for machine learning, then to be able to place the AI system in use, then of course the compliance with data protection should be ensured. And in the European Union, amongst other, general data protection regulation foresees aspects that are applicable to AI as well. And one of them is disclosure of information about profiling and logic involved. It foresees also that automated decision-making and profiling is prohibited except in certain occasions, and applying safeguards. And one of the safeguards is the human in the loop, but then of course is the question, who is capable to conduct an oversight, or what other safeguards may be sufficient. And the suggestion is that it could be anonymization, but then again, it may not be sufficient. For instance, if person-specific characteristics are processed, for instance, in rare disease cases, there is still a risk of re-identification. Furthermore, there is also an overarching desire to cloak everything under trade secrecy, as has been, for instance, the Compass case. Yes, and so to address issues related to AI, as first speakers already provided the comprehensive overview, then yes, in the spring 2021, there was a suggested proposal of AI Act issued that foresees, amongst others, also prohibition of certain AI applications, as well as mandatory conformity assessment or certification of high-risk applications. And as the last step, there is also disclosure of input training data in source code. But in the first step, there is a necessity to provide description of data that should provide a comprehensive overview also of demographic, geographical coverage, interconnection, and relevance. It is understandable because, for instance, just historical data cannot present like sufficient picture about the present or future behavior, and so on. The authors of the research deems that also this approach could be sufficiently or effectively applicable also, at least voluntarily, also for non-high-risk black box cases, because there also might be some sort of effect to the rights. Alternatively, there have been proposals to implement some sort of experimental proportionality. This tends towards the placement in the use of unproven AI systems, and then to test them in a real-world scenario and to see whether it turns out to be proportionate or not. And if it is not, then this application should be prohibited. Although to a certain extent, this suggestion may reflect the current situation, nevertheless, the regulation that is regulatory framework, both soft law and hard law, that is there in place in the European Union will not probably allow implementation of such an approach. And yes, and another framework where the criteria where the sufficient disclosure is a problem is the patent framework. And now I will turn to the analysis of the criteria of sufficient disclosure under European Patent Convention framework. So yes, European Patent Convention Article 83 foresees that patent applications shall disclose the invention in a manner that is sufficiently clear and complete for the person skilled in the art to carry out the invention. Rule 42 of implementing regulations foresees the content of description and basically asks that the written description should be in place except in exceptional cases, and also that non-compliance with this Article 83 can be the grounds for the opposition to ask to revoke the patent. Rule 42 of implementing regulation does not require for the person skilled in the art to actually carry out the invention, for instance, to write the code or to train the model, but asks compliance with three criteria. First one is feasibility, or to realize the invention from the written description and provided examples. Second is completeness, or realization by sample verification tests, applying reasonable effort and without additional experimentation. And third is repeatability, or the invention could be reproduced with a statistically acceptable frequency. Delineating the criteria sufficiently clear description, it should be outlined that it stands towards the notion that all described features in the applications are treated as equally important to carry out the invention. Therefore, those essential features and their interconnection and impact on the output should be clearly readable from the text. It cannot; these features cannot be omitted or ambiguous due to the mass of information. And one example is the patent application that was submitted before the European Patent Office, and the subject of which was neural network that was deployed to predict heart health related aspects. The patent application contained pretty vague explanations, as for instance, that invention deploys artificial neural network whose weighting values are determined by learning, or that input data should cover a wide range of patients. This application was rejected by the European Patent Office, saying that there wasn't displayed any technical effect that would exceed something that the person skilled in the art would understand by the artificial intelligence and specifically neural networks. And also because there was no expressly mentioned suitable input and output data sets. So therefore, this criteria sufficiently clear description wasn't sufficient. This ruling triggered the debate on whether or not the training data should be disclosed in each and every one of patent applications that deploys artificial intelligence. And the ratio behind the European Patent Office's notion on the training data disclosure is that performance of an identical process does not guarantee the same output if the logic remains unknown. So therefore, this wording in the opinion of the authors of this research is that not each and every one of the patent applications should incorporate disclosure of training data. Yes, but as the first step should be description of structure, functions, steps, methods, if feasible. So basically description of data, same as is proposed also in this so-called AI Act. And as one of the examples that is provided by the European Patent Office is, for instance, in classification algorithmic cases that, for instance, description could incorporate the wording images of human faces. Turning to the criteria sufficiently complete description, this basically stands towards the level of detail of this description. And according to European Patent Office, general data processing technology terms as kernel and others may be deemed as attributable to something technical only if a sufficient picture of the architecture of the system as well as interaction between the constituting components is provided in the application. And as an example for comparison could be mentioned Microsoft's application before the United States Patent and Trademark Office, where the application foresaw deployment of machine learning model, but the specific machine learning model was not mentioned. So basically, initially the Patent Office rejected this application due to the fact that the application artificially tried to widen the claimed patent scope. And the same approach takes also European Patent Office, saying that disclosure of training steps underlying algorithms should be mentioned, and just a pure reference to models as neural networks, support vector machine lacks the technical character if they are claimed per se. Additionally, it should be noted that there is no need for the invention to be ready for commercialization or the mass production at the stage when the application is submitted. So also the risk of injury or danger that the invention itself could encompass does not affect patentability. Therefore, authors of the research deems that the proposal that is there in the AI Act identifying prohibited AI applications and also high-risk applications would not have an impact on patentability. Of course, if the patent is claimed, if the patent is not claimed in the European Union. And also there might be occasions when there are two black box algorithms. And as one example is, for instance, the process patent claims where there might be difficulties to describe technical structure, for instance, of diagnostic algorithms. And in those cases, authors of the research propose several approaches what can be taken to render black box algorithms to white box algorithms. And first, apart from general description that was mentioned before, also appropriate data sets. Yes, all the data sets as well as sample verification examples could be disclosed. Alternatively, there can be description on the data correlations, experimentation results, along with sample verification examples. And the third option is to provide description on appropriate data sets, as is incorporated also in this AI Act proposal, how to certify these high-risk systems. That first step is this description. And also another aspect is that this description could be supported by clinical scientific evidence or decomposition or building model agnostic explainer. This approach has been proposed to certify black box medical devices, because there are also the same problems as in this field. Alternatively, there is a proposal that there should be introduced a deposit system of algorithmic model or deposit system of training data, the same as is in biological material cases. But this approach might not be supported by the European Patent Office, since the written description cannot be substituted by the deposit system. Also, there might be difficulties to implement this system, because just a pure disclosure of algorithmic model or training data such without the description may not be sufficient to still understand the underlying logic. And also, there is, of course, the aspect of trade secrecy, since the criteria sufficient disclosure does not require for the inventor to disclose everything that is related to the invention, but actually it is at the discretion for the inventor how much and to what extent to disclose. So, and turning to the conclusions, yes, the approach that is incorporated in AI Act for certification of high-risk systems could be attributable, at least voluntarily, also to non-high-risk black box algorithms. Although the practice of the European Patent Office provides examples how this criteria of sufficient disclosure should be fulfilled, nevertheless, more explanatory guidelines under the European Patent Convention regime, how to suffice this criteria in AI-related patent applications would be welcomed. Until then, the approach that is proposed in AI Act to provide this description written, or the approach that is taken or proposed to certify black box medical devices could be applied equally in patent applications as well. And with all that, I thank you for your attention.
Thank you, Leo, and great. I think your presentation was very interesting, and also it covered very complex and difficult questions. So thank you so much for your presentation. My pleasure now is to introduce to you our last speaker, Victoria Soņeca. She's a PhD student at the Faculty of Law, University of Latvia, and she will have a presentation on global technology giants and their influence on the sovereign. We are very excited and curious to hear your presentation.
Hi, sorry.
Victoria, we can't see you.
Yeah, hi. Today I have very bad internet connection, therefore please excuse me, but I will be presenting without the camera. I hope it's okay for you.
Thank you. Yeah, we can see it.
So, thank you again. And today I'm really happy to present my topic, global technology giants and their influence on the sovereign. In the last 2 decades, we have seen the rise of companies providing digital services. Big tech firms have become all pervasive, playing critical roles in our social interactions, in the way we access information and in the way we consume. These firms not only strive to be dominant players in one market, but with their giant monopoly power and domination of online ecosystems, they want to become the market itself. They're gaining not only economic, but also political power. This can be illustrated by Donald Trump's campaigns in order to influence the sovereign will, as the sovereign power is vested in the people. The Trump campaign's use of Facebook's advertising tools was responsible for Trump's win in the 2016 president election. After criticism regarding that election, Facebook said it will implement a series of measures to prevent future abuse. For example, no political ads will be accepted in the week before an election. It's a good example of how people before elections can be influenced in their decision-making. Other example how big tech firms can affect sovereign is by national legislator. For example, Australia had dispute with such digital platforms as Facebook and Google, and that was because Australia began to develop a news media and digital platforms mandatory code. For the Australian legislator to abandon the idea of the code, Facebook prevented Australian press, publishers, news media, and users from sharing, viewing Australian as well as international news content, including blocking information from government agencies. Such action demonstrated how large digital platforms can affect the flow of information in order to encourage the state and its legislator to change their position. Because of such pressure, Australia eventually made adjustments to the code in order to find a compromise with the digital platform. Also, when I'm referring to political power, I mean that tech companies are trying to influence European Union legislator. Such attempts they realize with help of lobbying. Tech giants are lobbying their interests to influence the European Union's digital policy, which has the most direct effect on the member states, given that the member states are bound by European Union laws and regulations. Also, it must be reminded that if a member state does not comply with European Union law, infringement proceedings might be initiated against the state. For example, the top 10 tech companies invest at least 1 million each on lobbying. There are only 6 companies that spend more than 2 millions. Google, Facebook, and Microsoft stand out with a lobby budget of more than 5 million each. When comparing corporate lobby spending across sectors, Google, Facebook, and Microsoft remains the top spenders in Brussels. Apple ranks 6th, following Bayer and Shell. That means that US tech giants are not only outspending other digital industry actors, but they are outspending all actors. Currently, most of the lobbying is focused on the Digital Markets Act and the Digital Service Act, 2 policy initiatives that could impact the business model of big tech firms. The Digital Services Act is set to update the legal framework which covers content moderation practices, including recommender systems and online advertising. The Digital Markets Act will target the excessive economic and monopolistic power of digital platforms by developing concrete behavior measures for platforms that control the access to market, so-called gatekeepers.
Victoria, we can't hear you anymore. I think we have lost Victoria. Okay, we have lost her presentation. Maybe we have to just wait a few seconds. Maybe she will come back. Let's just wait a bit. Yes, I think we can now continue with our discussion part, and if Victoria will manage to connect back, then we will let her to present her presentation till the end, but she has lost connection and just can't connect to us anymore. So maybe you have any questions to our speakers, so please feel free to ask. If anyone has questions, please raise your hands, and so I'm looking whether we have some questions in the chat. So it seems that there are no questions. So if no one of you would like to ask any questions, maybe I would like to I have two questions to all panelists. What do you see as the greatest challenges that AI and new technologies raise, and maybe also how do you think how important role do the new EU AI Act proposal and other EU proposals for new regulations like Digital Services Act and Digital Market Act would play in preventing and minimizing these risks and challenges which will be which are raised by new technologies, like such general more questions. Maybe you speakers could share their thoughts on this. Who would like? Maybe Liva, you like?
Yes. Okay. Yes, I will start. Yes, thank you for the question. The same thoughts, like what challenges and whether it is sufficient and so on. And yes, of course, AI may have various great aspects how to augment the human prosperity, but nevertheless, of course, it also entails various challenges that we've spoken today about. And in that sense, this new AI Act proposal is a great signal and a great starting point how to address these issues. And again, of course, there is a risk to over-regulate, and then some may say that it is some sort of interrupting incentive to innovate. But in my opinion, it has various great aspects and various very needed aspects, because so far existing soft law is not sufficient to tackle all those challenges that there are in practice in the same way, in more harmonized way. And in that sense, I would say that this proposal is a very great start how to address these issues, and also to establish more proportionate balance between the industry and between the human. Thank you.
Great, thank you so much, Liva. Maybe Vija, would you like to continue with these questions?
Yeah, yes, thank you for the question. And I think the question is very interesting, and there are many answers or many ways how to answer to this question. Talking about the greatest challenges, I would say that not only from the perspective of my paper that I was presenting today, but also from a perspective of other technologies, I would say the greatest challenge is to predict what will happen after 5 years or 10 years, how these technologies will develop. And it's very difficult to create regulation that will be fit and applicable to those new technologies that might just appear after a few years, and we cannot even imagine such technologies. On the other hand, talking about the role of the EU regulation, I would say that the E-Commerce Directive, the good old E-Commerce Directive, although with flaws, was, however, very successful. For 20 years, it actually performed and worked pretty well. And also, I think that, yes, on the one hand, it gives the hope that also the DSA will be of very good and high quality and will be applicable for many years to come. And also, I could say, and what I see is that the EU reacts faster than the national states regarding those technological issues. For example, at the national level in Latvia, we have non-discussions regarding those issues. But at the EU level, we have real proposals to potential regulations.
Thank you so much, Vija. I think you made great points. Does anyone else would like to address the questions about regulations? I think this. I see no one wants to speak, and yes, I think that these questions will get more and more important, and I would also encourage our speakers and others to continue these discussions, as there will be many questions regarding the new proposals at EU level, and also maybe to discuss them in the upcoming conferences that also will be organized at the University of Latvia. I would like to thank all of you here so much for being with us, and in particular to our panelists. It was a great pleasure indeed listening to your presentations and talking to you, and thank you very much again. So see you next time in some other occasion. Thank you. Bye.
Thank you very much.